Hi everyone, this is Nahid and welcome back to my video. Today I'm planning to say something about the cross-border insolvency litigations in Bangladesh and some other parts of the world. If we look at the legislation that we have in Bangladesh is the Bankruptcy Act, and if we look at the similar law in India, that is Insolvency and Bankruptcy Act 2016, they're almost similar. The nature of these two legislations are that they are territorialist, and in the territorialist legislations, the courts are given very simple power, very limited power to deal with the properties or debtors who are staying abroad. Suppose in Bangladesh, in a bankruptcy proceeding, it is very difficult to utilize the properties and liquidate them and distribute those monies among the creditors. The similar thing is also in India, and both those countries are really struggling to deal with the debtors who are abroad and the creditors in Bangladesh or in India. So India has made some significant developments in this cross-border insolvency proceedings, and what they have done is very important. Is they have put two sections in their Insolvency and Bankruptcy Act 2016. Is that section 234 and 235. In these sections, the central government of India can contract or deal with the foreign countries where the debtors are staying or where the property of the debtors are lying. Suppose the debtors are having some big buildings, some structures, property, bank balance, and all these things. The government can deal with the foreign countries to bring them back to the country, to India, and the proceedings in Bangladesh is also available but very limited, but the government of Bangladesh has in previous times successfully brought some properties back to Bangladesh from Singapore, where a lot of properties were garnered there by illegal means, and the government of Bangladesh has successfully done this with the help of USA and some other countries like So in these territorialist legislations, it is quite difficult. But if we look at some other parts of the world, we can see that the ancestral model law on cross-border insolvency in 1997 is a very important international instrument, and signed and ratified by a lot of countries, European countries. And this is a very important instrument to deal with cross-border insolvency proceedings. It is very easy to get access to the properties staying abroad. It is very easy to bring those debtors staying abroad to come to the local court and be part of the insolvency proceeding. It is very easy to liquidate those properties and distribute the money among the creditors. What is more important is the EU regulation, the European regulation 2015-848 is all about insolvency regulation, and this regulation has recognized a significant point known as COMI, COMI. COMI is Center of Main Interest, and it says that where to file a suit against the insolvent or the institutions. It says that the main insolvency proceedings can be opened in a member state where the debtor has its center of main interest. So the COMI, center of main interest, is the most significant point here. Suppose there is a company, which is an English company. It is incorporated in England or Wales. It is run by the English laws, and the parties are from England, the customers are from England, the directors are from England. So it is very easy to identify the COMI. The COMI of this English company is definitely England, and if the company is falling down, someone can file a suit for insolvency suit to put this company in the administration for the bankruptcy proceeding in England, in any English court. But suppose the English company has a subsidiary company in Germany, and what will happen to them? Suppose the Germany company is incorporated in Germany, the accounts, the papers, the filings are in Germany and run by the German laws. The customers are from German, and some things these are from Germans. But the thing is, in a similar case, in a realistic case, it was found that the director of the German company was from England, and it was brought out that the German company was actually run by the English directors, and as I have said earlier, it's a subsidiary company of the English company. So looking at all these factors and some considering some European Court of Justice decisions, the court finally found that the COMI of this German company is also in England. That is, if the German company is falling down and there are some people who are affected, they can file an insolvency proceeding in an English court, although the company is staying in Germany, although the property and the company properties are in Germany. So this is how the European regulations have recognized the legal issues and recognized the COMI system. So in Eurofood and Interdeal, the European Court of Justice has recognized some issues, that is, how to find out the COMI of a particular corporation or company. They say that objective factors which are ascertainable by third parties so that they themselves can determine whether a company is not based for the purpose of COMI in the member state where it has its registered office. And secondly, in Interdeal, the court said that it is necessary to determine the company's actual center of management and supervision in order to judge a company's COMI. So, looking at all these directions of the court and other issues, it was held that the German company's COMI is England, and the proceedings started there. Now, come to the subcontinental issues. That is, in Bangladesh, we don't have any kind of legislation like that, so that we can bring those debtors who are staying abroad come to Bangladesh, or bring those properties back to Bangladesh and liquidate them and distribute them among the creditors. In India, the government finally found that although they have the sections 234 and 35, that's not enough for dealing with cross-border matters. And they finally thought that being part of the unsettled model law, which is the cross-border insolvency legal instrument enacted in 1997, is the best option for the country, and it is also recognized by international monetary institutions and other organizations. And I think it will be very wise for developing countries like Bangladesh to become part of this unsettled model of cross-border insolvency. What happened in India is that they have, in a case, recognized the COMI, although they are not part of the European regulation. So, as I've said in earlier videos, that it is in this world of globalization, you cannot sit aloof, you cannot sit alone and do your things yourself. You have to comply with the requirements of some other countries, other group of countries, or other superpowers. Because, as I've said in earlier video, that the CISG is a very important issue, and although you are not a signatory or party to the CISG, you may sometimes be enforced, or your private international law can make you comply with the CISG regulations. What happened in India regarding cross-border insolvency transactions is that a airways company named Jet Airways India became insolvent, and it had some offices in outside countries like Netherlands. And when the company was falling down, some parties, they filed a some creditors, they filed a insolvency proceeding in Netherlands in Dutch court. After that, a similar insolvency proceeding started in India too. After that, the Indian court sent a letter to the Dutch court not to proceed with that issues because they have taken this matter in their hand. And the Dutch court appointed an administrator who came to India and applied in the Mumbai company court for stopping the proceeding in India because they have started the proceeding in Netherlands. So this is the way the situation was very turmoil, and it was uncertain what is going to happen to the creditors. So we're really looking forward to liquidate the properties and get some money to compensate themselves. And finally, the Indian court refused the request of the Dutch court's appointed administrator. The administrator actually requested the National Company Law Tribunal that they want to recognize insolvency proceedings which had commenced in the Netherlands and stay the insolvency proceedings in India against Jet Airways, since a competent court has, per Article 2(4) of the Dutch Bankruptcy Act, was adjudicating the matter in the Netherlands. So what happened is that the court refused the request, but they went to the appellate forum, which is the National Company Law Appellate Tribunal, and finally the appellate tribunal accepted the idea of COMI, that is, although the proceeding was running in Netherlands, the courts in India can also deal with that, but they will stop for a certain period of time after the completion of the proceedings in Dutch. They will implement those decisions here. So this is the way India has acknowledged or recognized the idea of COMI and the EU regulations. So this is kind of development that has happened, and it's very important and very appreciable that India has done it. It has opened up a big door. It has opened up a great opportunities for the Indian future cross-border insolvency proceedings. And I think this kind of developments in the Indian legal system is should be followed by other developing countries. I think the government of Bangladesh and the judiciary of Bangladesh can also think about all these developments so that the trans-border insolvency problems that we are having right now in Bangladesh can be solved, and look forward to make some other developments. And so this is for today. Thank you very much for staying with me, and Assalamu alaikum.